Welcome to EPG Pathshala. This paper is the philosophy of law. The module is Indian philosophy of law. The objectives of this module is to understand the possibility of thinking about a discipline called the Indian philosophy of law. I'm Akash Singh Rathore from the Department of Political Science at the Lewis University in Rome. On the origins of Indian philosophy of law. Law in India, as we know it, owes an enormous debt to the era of colonization. Family law, which includes Hindu law, Islamic law, what used to be called Mohammedan law, also springs from the British introduction to the modern legal system in India. But the source material, the customary cultural and religious practices that were codified into firm and fixed Hindu law, for example, date back well before the 17th century, or well before the codification of those customary religious practices as Hindu law or Mohammedan law done by the British. Similarly, various legal practices that came to be known as Muslim law flourished in several parts of India from the 13th century up until British colonization. Pre-modern legal systems, also pre-Islamic systems of so-called Hindu kings, date back to the late Vedic period. So from what I've said, I've pointed out four ways of understanding the Indianness of the Indian philosophy of law. You can see these as four phases of Indian legal history. There was the ancient phase, which was saliently the period of the practice of what we call now Hindu law. At that time, of course, it wasn't conceived as Hindu. This is a later construct, retrospectively imposed. But the cultural practices of law in the post-Vedic era. Subsequent to that, you have what we call the medieval period, saliently the period of Muslim law in India, at the same time as various Maratha regimes and other dynasties throughout the subcontinent, but the most prominent one is the Islamic law. The third phase I referred to as the modern, that is the period when Europeans, through colonial conquest, predominantly the British, imposed a kind of common law onto India, which subsequently became the norm and the way that we came to conceive law, even in the fourth phase, which is post-independence, that is post-1947, after the Indian nation state was formed, so after the Constitution. You can see that these four phases repeat what we're commonly taught in history, that Indian history has four phases: the ancient, predominantly Hindu; the medieval, predominantly Muslim; the modern, predominantly colonial, British; and the contemporary or post-independence. Now, many historians, Romala Thapar included, have sought to challenge this paradigm as being an imposition of a primarily European understanding of history onto the history of India. So I want to caution you of taking too seriously, too rigidly, this fourfold conception of the history of Indian law. The important point is that when we talk about the possibility of an Indian philosophy of law, what is it that we mean by Indian in this context? As I've pointed out, the Indian can refer to that post-Vedic, predominantly what we call Hindu, to the medieval, or what is prominently known as the Muslim, Mughal period, the modern, the introduction of British common law, and then the post-constitutional order. So these are these are different ways that we can refer to the Indianness of the Indian philosophy of law. So, with that in mind, you should take into account that what I'm calling here the Indian philosophy of law is actually a new discipline. As far as I know, there are no books of this title, there are no papers on this, but when you consider this fourfold history of the way that law has been practiced and conceived in Indian history, it's clear that we should be able to come up with a discipline or subject called the Indian philosophy of law. Now, certain prominent Indian legal theorists, you can think of Upendra Bakshi as one of the most prominent, and prominent judges, the Supreme Court judge Krishna Iyer comes to mind most readily, have argued consistently since the 1970s at least, that Indian jurisprudence, that's the practice of legal interpretation through administrative tribunals and courts, so on, is saturated with Anglo-American legal theories. In that respect, relevance to the Indian context has not been established. Krishna Iyer, Upendra Bakshi, and others have argued that the actual legal system and the theoretical discourse of the philosophy of law lacks the imprint of India's specific cultural, climatic, or geographical conditions. Now, this is a very strange suggestion. Why should our climate or our cultural conditions have something to do with the nature of law? Well, when you think about what the philosophy of law is, in earlier modules you have studied John Austin or H.L.A. Hart or other philosophers of law who have essentially abstracted conditions of lived legal and political life and legal and political experience, abstracted those into the essences or norms that get represented through the practices. In other words, philosophy of law, just like philosophy as such, is an abstraction from elements and experiences. Now, if the philosophy of law as we understand it in India is an abstraction of practices and experiences that have happened thousands, and in most cases 10,000 kilometers away, how is it that these laws should in any way reflect or represent the lived political realities of the Indian people? So the idea behind an Indian philosophy of law is to suggest that the theories that we propose as Indian philosophers, as Indian jurists and legal practitioners, that these theories should reflect the real and best practices of the Indian population. Indian jurisprudence should be Indian in origin, in content, and in application. It should be, as philosophers say, sui generis, of its own kind, and not merely borrowed or derivative. The common man in India is largely distanced from the legislative language and the legal theoretical language that is practiced and preached in this country. And while that's common the world over, there's certainly a sense in which if you were to, let's say, wake up a slumbering American in the middle of the night and ask to explain what is justice, let's say, or some other principle that's espoused in the American Constitution, that the words that they would mumble sleepily would in some way recapitulate or touch upon the very same ideas that appear in that Constitution, which themselves reflect the theories that appear in American legal theory. But this is very different from the realities here. If you approach an average person, even decently educated, and ask about the conditions of law or a definition of equality, the idea that the words that are articulated in the Indian Constitution, in Indian case law, in other words, the way that the judges decide cases in line with the Constitution, in Indian administration and regulations, will not be the content that so freely comes out in the vernacular language of the person that you ask. And this asymmetry, this mismatch, is both caused by and perpetuated by the fact that the theoretical understanding of law in India has been largely transplanted from contexts and circumstances that are thousands of miles away. In other words, in the recent past, academic concentration on Anglo-American philosophies of law, and in the more distant past, the British imposition of common law in the country. Now, I had mentioned 4 phases of conceiving of the history of law in India, and the earliest phase that I had mentioned was the ancient Hindu legal theory and practice. Ancient Indian philosophy speaks of dharma, which is sometimes translated as law, especially in the books that are dedicated to legal thought, and the duties of the king with respect to the law, or the Raja Dharma. It's interesting to note, in terms of the philosophy of law in this era, that the king is not seen as sovereign over the law. This is what you would have noticed in earlier modules in the philosophy of law, for example, in Hobbes's conception, or most pointedly in Carl Schmitt's philosophy of law. The sovereign is he who is above the law. In the ancient Hindu understanding, the king is subject to the law. Here's a passage from the Brihadaranyaka Upanishad, which states that law is the king of kings, far more rigid and powerful than they are. There is nothing higher than law. By its prowess, as by that of the highest monarch, the weak shall prevail over the strong. So there's this sense that law is above even the sovereign, who is the representation of the law in this secular sphere. Now, what I call Hindu law in this era is, of course, in some way an anachronism, because they didn't see themselves as Hindus. This is a term that we put on later. And in this environment, there also weren't law as we conceive of it as such today. There were customary practices that eventually were reflected and refracted as best practices, or in some case, to be honest, worst practices, through the Shruti and the Smriti. What is codified in Manu's laws, for example, may or may not have reflected the actual practices. Personally, I hope they didn't. But what we can see is that when laws are codified and written down, there are 2 possibilities. One is that these are the actual practices that are recorded, or quite the alternative, that none of this was practiced, and therefore the need to write it down in an attempt to impose a kind of order. Nevertheless, in subsequent legal history, when the British were looking for so-called indigenous rules and regulations and modes of governance, they picked up Manu and assumed that, this must be the way that the Indians ruled themselves. Whether that is true or not is open to historical. Family law, what I had called, in some respects, is the ancient made modern. So we have family law today under the current constitution, which is an attempt to incorporate elements of pre-modern law. In other words, Hindu law, what used to be called Muhammadan law or Islamic law, are now codified as contemporary law, when in fact they are ancient customary practices. Well, when we look at the ancient world and this way of modernizing ancient practices, as in family law, should this be the model for what we call Indian philosophy of law? I mean, if we want to leap back over the imposition of foreign laws that don't necessarily jibe with the spirit of indigenous or everyday Indian practices, is the solution to be found in leaping back to the ancient world, to that wonder that was India, picking up those laws and imposing them today? Well, that should hopefully strike you as rather absurd, because laws are not just norms that float freely in space. They're concretized in institutions. And the contemporary institutions of this country, post-1947, and in accord with the dispensation of the Constitution, are radically different from the environment and the circumstances of a post-Vedic period. So a resurrection simply of dharmashastras or smritis is not a viable option for the definition of Indian when we seek an Indian philosophy of law. It has to be more subtle, more historically sensitive, and more sensitive to the contemporary, deeply plural society that India is. Thus, a resurrection of the Dharmashastras is not viable as filling in the content of what we mean by Indian in the idea of pursuing an Indian philosophy of law. And something similar goes for the Muslim period. While what was called Muhammadan law has been incorporated into contemporary law through family law, and of course you're familiar with the debates about making uniform our legal system. What is clear is that the plural conditions of today would make it impossible to simply impose some ancient set of rules and regulations as the way to discover the authenticity of Indian philosophy of law. But what is authentic Indian philosophy of law? This is a compelling question, because on the one hand, it's clear that we need to overcome the derivative philosophy of law that we've been working with and that are available to our judges and constitutional experts, and at the same time that leaping back over to either the wonder that was India or the glorious Mughal era is not going to be the source for the indigeneity or the authenticity of Indian philosophy of law. So we can look now at the modern period and see what resources we might find there. Dr. B.R. Ambedkar saw the Indian Constitution as a means of legal social revolution and incorporated ideas of liberty, equality, and fraternity in it. These are considered very modern concepts, and they are at times considered to be alien to the Indian soil. But if you look back within earlier eras of Indian history and reflection on norms, equality has been a forefront concern for predominantly critics of caste and inequality from the time of the Buddha through Tukaram and many 12th, 13th, 14th century writers and poets, right up to Phule and Ambedkar in the late 20th century. The Constitution then can be seen to represent both legal transplantation, for example, the introduction of elements like liberty, equality, and fraternity from a French or an American point of view, as also representing elements of heterodox Indian traditions that have existed in Buddhist, Jain, Charvak, and other Indian philosophical traditions. It also has Gandhian and Nehruvian elements, and if you would like to see more on the Gandhian philosophy of law, there's another module in this paper that treats of that. The legal social revolution that Ambedkar had talked about is an interesting, modern, but still authentically Indian way of understanding the purpose, function, and theory of law. We have something called public interest litigation, PIL for short, and the philosophy that has been articulated by judges and advocates and lawyers behind the PIL is quite consistent with a homespun sort of Indian philosophy of law that regards the authenticity of Indian legal theory as referring to representing and pursuing the interests of the Indian masses at large. In other words, we're at a moment when we understand that we have legal transplantation that is largely conceptually alien to our vernaculars. And we have the option of leaping back over that to some ancient or medieval era. That option is not open to us given the contemporary pluralism and the institutions of governance that are now very deeply entrenched in Indian culture, parliament, judiciary, democracy as such. So what other option is there? Ambedkar proposes, in his articulation, the option not of leaping back, but of going down. In other words, down to the people. The people are, of course, the locus of indigeneity and authenticity. Justice Krishna Iyer made a very interesting observation that is parallel to what Dr. Ambedkar had said. In a judgment in the shortly after the Constitution was enacted, he stated, "I am clear that the Constitution is not for the exclusive benefit of the government and states. It is not only for lawyers and politicians and officials and those highly placed. It also exists for the common man, for the poor and the humble." This is quite interesting because this is a new way of understanding the Indianness of an Indian philosophy of law. It doesn't necessarily have to overlap with certain orthodoxies in our past. It can also reflect the way that law is meant to reflect and the origins of law in customary practices. The very customary practices, the best practices of the common man in this country, for whom the laws and this Constitution are supposed to be created. Some Indian philosophers of law and prominent judges suggest that India, since independence, has in fact rejected the legacy of English statutory and common law. In other words, the practices of common law have slowly been overcome through new modes of legal interpretation practiced through the courts, and that the Indian Supreme Court, the Delhi High Court, have evolved a kind of indigenous, or let's say Indian, legal theory, and have started to generate principles in line with the indigenous needs and ethos. Again, Krishna Iyer stated that here is one example of how an indigenous principle has crept in to numerous decisions made by the Indian Supreme Court throughout the 70s and 80s. The judge said, "Where doubts arise, the Gandhian talisman becomes a tool of interpretation. Whenever you are in doubt, apply the following test. Recall the face of the poorest and the weakest man whom you may have seen, and ask yourself if the step you contemplate is going to be of any use for him. Law, at the service of life, must respond interpretatively to raw realities and make for liberties." So the direction here of finding authenticity or finding indigeneity in the philosophy of law, in other words, in defining the content of Indian when we say Indian philosophy of law, turns out to be, interestingly, to follow the very same direction that law historically was developed to do. In other words, represent the interests of the people who are being subject to the law. And if those interests are the Indian people, and if we recognize that the Constitution and the legal system are to be interpreted not in line with, let's say, Austinian legal principles, as they would do in the United Kingdom, or with Hart's or now Joseph Ratz's legal thought, as they might do in the US Supreme Court. If instead we evoke, for example, the motivations behind the Gandhian, the Ambedkarite, or the Nehruvian elements that are visible in the Constitution, in its spirit and its laws, this might be a way of understanding the Indianness of Indian philosophy of law. So one of the foremost elements of India's newly emerging indigenous philosophy of law is that it has to be consistent with our society. And our society is a deeply plural society. However, just the same, we don't exclude the practices and principles that have evolved elsewhere, provided that they pass muster. I mean, we don't exclude something just based on its foreignness, just as we don't accept something based exclusively on its indigeneity. However, there is a test. We don't take the foreign thing just because it's a best practice elsewhere. We have to adopt it in keeping in mind the peculiarities of our culture, climate, and plurality. To sum up then, the task of an authentic Indian philosophy of law is to continue to broaden the sweep of humane and egalitarian legal thought and practice. PIL is one example of it. And the pursuit of what Justice Krishna Iyer had called the Gandhian talisman is another articulation of the same. At the same time, we should reform and rewrite our own laws and legal practices in a manner that reflects the best practices of our own traditions. In other words, as of yet, there are so many local practices that have failed to be incorporated into legal documents. Panchayats, for example, are a case where practices, indigenous practices, have been elevated to the point of constitutional law, but there are so many others that could easily be adopted that were resisted because the British felt that these were customary practices that were not noble enough to qualify as law.